Thank you all for being here. Congratulations, you made it through 3/4 of the presentations. One more to go, and we're going to talk a little bit about whether or not you should stay in Connecticut. But before I do, I'd be remiss. Liz briefly mentioned the fact that a year ago we came on board. It was almost exactly a year. It'll be a year next week that Dick Emerson, Tom Rickert, Frank Cinto, and I merged our practices in with the folks at Chipman Mazzucco, and it has been a fabulous year. We've been fortunate enough to work with some great attorneys, fantastic administrative staff. It's a great place to be. In terms of Connecticut, when you talk about whether or not you're going to stay in Connecticut, we've all seen commentaries, pundits, people talking about how awful it is. The state pension is this, is a mess. Taxes are awful, and to a degree there are problems there for sure. But take a drive up Route 7. Take a look at how beautiful it is. Take a ride down on the coast. Look at how beautiful it is. We're tucked in between New York and Boston. We've got all of those things that those places have to offer. We've got great schools. It's not such a bad place until January. Then the only thing we can think of is how quickly can we move south. Maybe the Caribbean. Maybe a trip out west to California. When we look at retirement, we look at the various places we might go, and we think about a second home. Maybe it's a boat. Maybe it's not a home. But first, when we determine this, when we look at it, when we look at where we're going to go and what we're going to do, we have to look at it from a financial standpoint and a tax standpoint, because there are very important issues that should be dealt with before you go, if you choose to go at all. So we first look at what is the state, and I mean the state of Connecticut, and I'll refer to the state a lot throughout this presentation, and I'm going to refer to Connecticut only for a while. The reason being is that if you are current Connecticut residents and you try and leave the state, we worry about the state asserting jurisdiction over you for tax purposes. So we establish what's called a domicile. And a domicile is the place to which an individual intends to make his or her permanent home, and the place to which they're going to return after being absent for a while. It's an incredibly important definition, if you will. Once established, the domicile remains unchanged unless you move to a new jurisdiction, a new location, with the intention of making that new location your permanent home. You generally can have only one domicile. Connecticut regulations state it, but the case law says otherwise. Take, for example, folks who commute to and from New York. Folks in that situation, when they're working in New York, may have income derived in New York. They may go in so often that they buy a small apartment, and they spend their time there when they're working, and they're back here in Connecticut on the weekends or evenings sometimes. It really depends, but it depends upon how much time you spend in New York, because New York is looking to assert jurisdiction over you. So we have to be very careful, because two competing states, because you could establish your domicile in Connecticut, but New York is going to say you're a resident here too. So both states could assert a tax as a resident. For Connecticut and most other jurisdictions, residence means maintaining that permanent place of abode and spending more than 183 days in Connecticut. If you're going to change your domicile, remember that 183 days, that's an important time, and we'll get back to why it's not necessarily set in stone. But if you're going to change your domicile, there are a number of factors that the state of Connecticut is going to look at. The regulations actually have 28 different ones in addition to that 183 days. But if you establish your permanent place of abode, in certain states you can file what's called a declaration of domicile. Florida, for example, has one of those, and it's generally a county produced form. Dade County, for example, produces a form called the Declaration of Domicile. When you get there, register to vote. Obtain your driver's license in that new jurisdiction as well, and register your cars there. Try not to keep anything that can be traced, for example, an automobile, in terms of title, here in Connecticut. File your 1040, your individual tax return, with the service center appropriate for the jurisdiction in which you're living. Don't file it as though you're a Connecticut resident, and make sure that the address on your return is your new domicile, your new home. And wherever possible, maintain financial accounts with local banks. At least change your address so that all of your statements, credit card statements, bank statements, financial advisors, their statements, virtually everything reflects your new address. Change professional licenses and union memberships wherever you can. If you can't, make sure that the union, or for example, for me, a bar association, would be aware that I was no longer a resident of Connecticut. Become a non-resident. The same thing applies for social, fraternal, charitable, religious institutions with which you're affiliated. Make sure that they know that you're not a resident of Connecticut anymore. And finally, keep a record of your travels. And we'll get into why this is important in a moment. Keep a log of where you are on any given day throughout the year. As I said, Connecticut has a laundry list of these items. Things like hunting licenses and fishing licenses. If you like to hunt or fish in Connecticut, but you want to be considered a Florida resident, when you get a hunting license up here, don't do it as a resident, do it as a non-resident. They actually look at these things, but treat your new home as your domicile, and particularly if you're going to maintain real estate here in Connecticut. Connecticut is DRS, the Department of Revenue Services, is extraordinarily aggressive when it comes to estate tax and income tax. If they think that you are actually a Connecticut resident, even though you may be living somewhere else, they will pursue it. And that 183 days, for example, that's only one of the criteria. They don't think that's set in stone. They will look at each and every item on the list and try and determine what your intent really is, based upon what they consider an objective standard, which we all know it's not, but this is how they approach it, and they can drag you back in for estate or income tax purposes. Certain things you can do to be proactive here in Connecticut, and for example, remove your name from the voting rolls. Actually physically surrender your driver's license. Make sure you have your new one first. Notify municipal and tax authorities of your intent to go to the new place, so that your property tax bill, if you're maintaining your residence here in Connecticut, goes to your address in the new jurisdiction. Don't cut it close to the 183 days if you're going to do this. I've had folks say to me, I've already plotted it out for the year. I'm going to be in Connecticut 182 days. And I say, please don't do it. Please don't do it. Even a portion of a day counts toward the 183 days. And things will change in your life that will result in you spending more time in Connecticut. A grandchild. 2 years ago, she happens to be my grandchild, my granddaughter. 2 years ago, we were thinking about retirement in the Caribbean. She came along. We're not going to the Caribbean, or if we do, it's just going to be for an extended period of time. Things like that will draw you back into Connecticut. Health issues. If your doctors are up here, that can draw you back into Connecticut, if that's where your treatment is and where you feel comfortable being treated. So be very careful when it comes to that timing. If you think the DRS can't find out, they can. They have access to things such as your Easy Pass records, your cell phone records, your ATM usage. If you claim to be in New York on a day when you used an ATM in New Haven, They'll know it. So even that part of a day. Now, days in transit can be considered not being in Connecticut, but they're not going to be very cooperative when it comes to you making that argument. Now, many of our clients, regardless of their domicile, maintain a second home in other jurisdictions. I think Cape Cod is probably the most common one for around here. Martha's Vineyard, Cape Cod, Florida, all of these places are places, pretty common places for folks to have a second residence. So what we also look at is what happens if there's an estate tax in that other jurisdiction. So we'll take, for example, for tonight, Massachusetts. Cape Cod, you have a home on the shore. Massachusetts has an estate tax which kicks in after $1 million. So we want to be careful that the home on Cape Cod does not get pulled in to the estate tax regime in Massachusetts. Nor do we want it involved in the probate system up there. Probate in Connecticut is relatively informal, fairly easy to get through now. Massachusetts, it's not. Florida, it is not. All of my clients in those jurisdictions who have property in those jurisdictions have revocable trusts, and they've quitclaimed their properties into those trusts, by and large, especially Florida, because you can avoid probate altogether, and there's no estate tax. But what do we do in Massachusetts? There is a means by which you can avoid probate and you can avoid estate tax in Massachusetts. And I'm not going to say it's easy, but it's not terribly complicated either. What we do is we create an LLC. And we do a Connecticut LLC generally, because it doesn't change, the cost in terms of registering it in Massachusetts. But we do an LLC in Connecticut. And then we quitclaim the property in Massachusetts into that LLC. Okay? So now we change the fundamental nature of that asset. When before the transfer, you owned real estate in Massachusetts. When you put it in the LLC, you own an LLC interest, a business interest. Massachusetts does not have automatic jurisdiction over that property for tax purposes because you don't own the property, you own the LLC. We then take the LLC and we drop it into a revocable trust. Now we've got 2 layers between you and the state of Commonwealth of Massachusetts. And it works pretty well. It's a little cumbersome and it is costly. You're paying $500 a year, for example, to register your LLC in Massachusetts. It's $500 to create the LLC. And then the cost of a quitclaim deed and those sorts of things. But once it's in there, you've really protected yourself, or better yet, your family, from the estate tax regime in Massachusetts. The one caveat here is I mentioned that we changed the nature of the ownership of that property from real estate to a business interest. Well, what that does is, if you're a Connecticut resident, that LLC is now part of your taxable estate here in Connecticut. So it will bump up your taxable estate here, resulting in a slightly higher probate fee in Connecticut because the probate fees, the statutory probate fee, is based upon your gross taxable estate. The fortunate thing is that Connecticut has lifted the exemption, and we're at, as Dick mentioned earlier, we're at 3.6 million, going to 5.1 at the beginning of next year, 7.1, 9.1, and ultimately in 2023 we're going to be paralleling the federal tax estate tax exemption, which is now at $11.4 million. So a married couple has between them roughly $23 million that they can protect for the next generation. Better than the $1 million in Massachusetts. Now, does the reciprocal hold true? Now you're a Florida resident, for the sake of argument, and you've maintained the home in Connecticut. So do we do the opposite? Do we set up a Florida trust, a Florida LLC, quitclaim the Connecticut property into the LLC, and then into the trust? Well, it used to be yes. Now you've taken your property, your vacation home, your rental property, whatever it might be, and you have removed it from consideration for Connecticut estate tax purposes. As far as I know, Connecticut is the only state that did this, because earlier this year they passed House Bill 7373, became Public Act 19-186. What it said, buried in subsection 31 of this bill, is that that no longer works here. That if you drop your real estate into a pass-through entity, that it will be considered yours for estate tax purposes and subject to Connecticut estate tax. Now, again, you'd have to have a fairly hefty home for this to apply, but we don't know what's going to happen to the federal estate tax because in 2026, that the provisions with the 11.4 million, as I mentioned, that's going to sunset. We're going to drop back to 5.4 million or whatever it might be at that point, but it will be considerably less. But Connecticut somehow got wind, I don't know how they did this, but they passed this legislation which says that this technique will no longer work in Connecticut unless the way around it is make sure once you put this property into an LLC and that it is used for some form of business venture, some venture for profit or loss. Because that's the way to get past this statute. Now, it has to be a legitimate business purpose. And we don't know what the state is going to do as far as this is concerned because it is so new. I mean, it's not even in effect yet, quite frankly, but it will be. So keep an eye on that, and we will as well. Obviously, there's no case law for which we can interpret this. We just don't know. So with that said, wherever your retirement takes you, wherever you choose to go, I'm not terribly concerned about, from a tax standpoint, where it is you choose to go, because there are all sorts of things we can do to help make it easier for you, for your family, make the burden financially a little bit better, so that whether it's a boat on the Chesapeake or the Outer Banks or the Caribbean, you're enjoying life.